Good evening. Thank you for joining us. My name is Jordan Bennett. I'm the owner of Jordan Bennett and Associates at Keller Williams Realty. We help people buy, sell, and invest in real estate and also offer consulting and property management services to clients. I want to personally thank you all for joining us tonight for this informative evening. I'd like to introduce to you tonight Nick Henry with First American Trust and Jill Kinsey of Albrecht and Barney. Nick specializes in trust administration and investment management, and Jill focuses on estate planning. And we get questions all the time from our clients about these two fields, and many don't realize the importance of having a plan in place. And so that's a little bit about what we are going to be talking about tonight. These two are both experts in their fields, and I'm going to let them take the wheel, briefly introduce themselves further, and tell us a little bit about what we're going to be talking about tonight. So Nick, why don't you just tell us briefly about yourself?
Yeah, so I've been in the financial services industry, going on 11 years now or so. Kind of had my hands in a little bit of everything. I've been with First American 3 years now. So my primary responsibilities there are, as you mentioned, investment management and trust administration. So it's kind of what I do day in and day out, just serving our clients.
Great. So. How about you, Jill?
Yeah, so I've been in estate planning practicing for the last 5 years. Actually been with Albrecht and Barney for coming on 10 years now, so been immersed in the estate planning world, doing everything from initial planning for young families or elderly couples that need to revise, and also through trust administration and probate. So kind of the whole realm of estate planning, we kind of handle it all.
Fantastic. Well, we're going to start with some questions for Jill. So tell me briefly, in a nutshell, what is a trust?
So a trust is a document that basically says what you want to happen with your assets and your property when you pass away. It's very similar to a will, but the difference is wills must go through probate here in California, which is an awful court proceeding. If anyone's heard about probate, they usually know it's bad. But yeah, it's awful, it's expensive, it takes a long time. So a trust is the same type of document, but you can get a lot more specific of who gets what, how they get it, who's in charge. If you have young kids, we can put in all those bells and whistles of timing it out based upon ages, or holding it so that someone else is managing it until they're a good age. So there's a lot of additional kind of fancy language that you can put in, whereas a will is usually typically pretty basic.
Okay, so do I need to have a trust to avoid probate?
So if you have assets, so the probate threshold is $150,000. So basically here in Southern California, if you have a home, your home is going to be worth more than $150,000. That's just the way it goes down here. So if you have a home, yes, or assets valued over $150,000. You can try to avoid it via beneficiary designations and things like that, but on a home, when you have more of those complicated assets or dynamics, it really makes sense to have a trust so you can avoid going to court.
Okay, so tell me a little bit about what it looks like if I pass away and I don't have a trust.
So first, in this scenario, are you married?
Yes.
You're married?
Yes.
Kaylee's right there. So what happens is if everything is titled jointly with your spouse, it's very easy, and it usually goes by right of survivorship to your spouse. So you're okay if only one spouse dies and you have everything titled jointly. You will probably be in the clear. There's some tax advantages that you can get through having a trust, but everything will pass to the spouse. It's really if something happens to both of you, you have to go through probate, and it's about a 1.5 to 2 year procedure of going to your heirs at law, and that basically just has a trickle down effect if you have kids, equally among the kids, and vice versa.
So tell me briefly about probate. Why is it? What's so bad about it?
So first I talked about the time frame. So the Orange County courts in particular are very backlogged. So it's taking about a 1.5 to 2 years to get through that process from start to finish. And those are mandatory time frames that you have to adhere to. The second part is the fees. So attorney's fees, so that's my fees, are calculated based upon the fair market value of your assets. So that means if you have your home and you have a mortgage on it, I calculate my fee based upon whatever Zillow says it's worth, and I don't even take into consideration your mortgage. So right now we're looking at, for let's say a $500,000 home, the probate fees to me is about $13,000. That's really expensive. So for $1 million, we're talking about $20,000 to $23,000 just to go through that process. I'm not doing anything fancy. That's not litigation. Everyone's on good terms.
Wow.
That's just a statutory fee under the probate code.
Gotcha. And that's in addition to paying all the regular fees of selling a piece of property.
Correct.
Yeah.
Yeah, it's expensive.
It's a big
Good
deal.
for me, but bad for everybody else. So I still try to avoid probate because I don't like it either.
Yeah, that makes sense. So tell me briefly, can I create a trust on my own? Can I use, a service on the internet, or why do I need to hire an attorney?
Yeah, so technically, yes, you can create a trust on your own. LegalZoom is very popular nowadays, and usually I say if you have a very basic family and basic scenario, you can probably get away with a LegalZoom document. If your kids are adults and they're financially savvy and they all get along, you might be okay. But if you have any of those additional circumstances, maybe a blended family, so we have stepkids coming into the scenario, remarriages, or if we have kids with special needs, or maybe we have minors that we want to make sure don't just get everything at 18, then it makes sense to talk to an attorney because they're going to flesh out all of those items that LegalZoom isn't going to ask you, do you have a child with special needs? They're not going to ask you, you're naming the two kids together, well, do they get along? Are they even going to be able to administer this trust and make a decision?
Right.
So those are the types of things that attorneys can flesh out, whereas LegalZoom is just fill in the blank, basically.
That's great. So we didn't prepare for each of these questions, so I'm going to put you on the spot a little bit. Let's say I have a kid that doesn't necessarily have special needs, but I don't know, he has drug addiction problems, and I'm concerned that after I die, I don't want him necessarily to get this big chunk of money. What are maybe some creative things that people do to kind of mitigate against, how the money flows?
Yeah, so there's different ways you can set it up. So we have ways that you can actually hold the assets in trust for that child with someone else managing it. And we have what we call in our firm beneficiary misconduct language, which actually says if the beneficiary is on drugs or has been incarcerated or is having issues, the trustee can actually withhold distributions that would have otherwise been made to that child under the terms based in their discretion. So you kind of have a third party managing that money for them.
Okay.
And sometimes that's nice when we get people like Nick and First American Trust involved because they can potentially be that third party. So you're not having to have their sibling or their aunt or uncle be that bad person that's withholding distributions or kind of keeping their money.
Okay. So funny question for you. Let's say I have, not the case in my situation, but let's say someone has two kids and they like one kid more than the other. And that actually they don't want to give anything to the one kid because he never calls and never comes to any family events, and he's just not really a part of the family. Does the person passing on their estate have any responsibilities, obligations if they have multiple kids?
So there's actually no obligations to give the money equally to your children. Now, of course, that's the norm, and that is actually what California law says would happen. So if a husband and wife pass away and they have 3 kids, if they had no planning in place, it goes equally a third, a third, a third. So especially in those cases where you're planning on not doing an equal distribution, you really need to plan so that you can say what you want, because you get to say whatever you want. If you wanted it all to go to charity and 0 to go to the kids, that's 100% your choice.
Yeah.
And you can give it to whoever you like. So it's actually not uncommon that happens. Family dynamics are hard. Everyone has a different family.
Absolutely. So let me ask you this. When you create a trust, can you set it and forget it? Do you need to circle back and check things out and kind of keep a pulse on it? What does that look like as far as maintaining your trust?
I usually say give it about every 3 to 5 years. You should take a look at it, or at least reach out to your attorney. Or usually I like to work a lot with financial advisors and CPAs because they're having the annual touch with their clients to kind of review everything, and it's kind of a good way to say, oh, when's the last time you talked to your attorney? Do you know who's in charge of your trust? Has there been a death in the family? Maybe we need to do an update. So it is kind of a set it and forget it because they're always still valid once you set them up, but it's good to do a refresher, or at least understand what's going on about every 3 to 5 years.
Every 3 to 5 years. Okay.
Yeah.
That's good information. How about, I know you're not a CPA, but as far as the tax side of things, if I set up a trust, what do death and inheritance taxes look like? Do my kids have to pay taxes on all the stuff that they receive?
So right now, there's an estate tax exemption. So that's what the federal government says you can pass down to your kids or to any of your beneficiaries free of estate or inheritance tax. And right now, that threshold is actually 11.18 million. So last year, it was only 5.5. Under the new administration, it's been increased to about 11 million, sorry. And that's per person. So for a couple, they can pass $22 million down to the kids free of estate tax. So most of us dream to have that problem. So that means most of our beneficiaries aren't going to be paying an estate tax. However, that number does fluctuate. So it's good to, like in our firm, we send newsletters to our clients anytime there's an update in the estate tax field so that we can make sure that if they need revisions, if they're now above the thresholds, they can do that. So for most of the people, though, there is going to be no inheritance tax from a federal level. And California, one of the good things of California on tax-wise, we do not have a state estate tax or a state death tax. California does not have that, whereas other states do.
Okay, great. So tell me a little bit about creditor protection. How does a trust help me as far as, let's say there's people out there that want to get to, the assets in the trust. What does that look like?
So if you have your revocable living trust, which is primarily what we've been talking about, of setting things up for the kids, while it is revocable, you don't get any creditor protection. Okay. Because since it's revocable, you have full access, full control over all of those assets. So you don't get any of that protection because it's still really yours. But there are scenarios where if one spouse passes away, we might be setting up an irrevocable trust, which means you can't change the terms. And that's when that creditor protection can come in, so that if the survivor's, now in their 90s, still driving and gets into a car accident and gets sued, well, the deceased spouse's half could still be completely creditor protected in an irrevocable trust. So it could be kind of as a nest egg to make sure if anything awry goes on down the road. Okay,
and an irrevocable trust, that's kind of more something that not necessarily, a family with young kids would be setting up. We're talking more about people towards the end of life.
Correct, towards the end, or people who are above that estate tax threshold. So above the 22 million, there's ways that you can set up gifting trusts or irrevocable trusts right now and start to gift assets away to the kids and get creditor protection.
Gotcha. Okay. And tell me a little bit about, let's say that you have an aging parent or grandparent that wants to add a child onto title of the home in order to avoid probate. Does that work? Is that something somebody should do?
Yeah, so technically it works. So by adding a child onto title to the home, typically people do it as what's called joint tenants. And what that means is that it has a right of survivorship, so that if one of those joint tenants dies, it automatically transfers to the remaining joint tenant. We usually suggest against it because for tax purposes, when they add their child on title, it's technically a gift of half of that property to that child. It also opens up the child to liability. So if the parent were to get sued, that property could be taken away as part of their assets. Also, you miss out on what's called a step up in basis on that asset. So this is all about capital gains tax. When someone passes away, the IRS lets you step up your low cost basis on those assets so that you can sell and pay zero capital gains tax. So if you add a child on there, you only get a half step up in basis versus 100%. So it's primarily tax purposes that you don't want to do it, but for probate avoidance, it does work, provided mom and child don't pass away together. Then you still have a probate problem.
Gotcha. And so essentially that means that if somebody, bought a home 20 years ago for $100,000, today it's worth $1 million, and if they added the child on there and they sold it today for $1 million, they would be taxed on that gain.
Correct.
Versus if they did not add the child and passed it through the trust, they would get that step up. Now if they sell that property, this basis is $1 million, they pay zero tax.
Correct.
Yep. Okay.
Correct. So really advantageous,
Huge.
Especially here in California.
Yeah, absolutely. So can you talk a little bit about the different ways to hold title, let's say for, either, let's talk about a regular, homeowner, husband and wife. What is the best way? I don't know if you could say the best way, because then you're giving legal advice. But what?
My preferred way.
Yes, your preferred way.
So one of the ways is through a lot of what we see from home purchases in the 80s or 90s and early 2000s is husband and wife joint tenants. It works for probate avoidance, but again, from a tax perspective, you're only getting a 50% step up in basis when one spouse passes away versus 100%. So there's a new way you can hold it, which is husband and wife community property with right of survivorship. So you get the best of both worlds. You get to avoid probate at that first death because it goes to the other joint holder, and then you also get a double step up in basis because it's held as community property, which means what's yours is mine and mine is yours, so we get 100% step up versus only 50. Also, the preferred is in the trust. You avoid probate no matter what, and usually we say within the trust, if it's joint, it's community, so we get that double step up in basis.
Okay. How about out of curiosity, how about for partners? Let's say two friends want to get together, partner up, and buy a piece of property that, they're not married, they're just friends, and there's a level of trust there, but they want to make sure they're both protecting their bases. Yeah. What do you recommend in that situation?
So they can do it one of two ways. They can do the joint tenancy, which means if one of them passes away, it goes to their partner that owns the property. More common, we see tenants in common, which means that they each have their 50%, and when they pass away, it goes pursuant to their estate documents. So they get to say where it goes. So if they, let's say they buy, a lake house together, they own it as joint tenants, and they get to say where it goes. So it stays within the family and all of that. I would also suggest having an agreement, a co-owner's agreement, just so that if someone wants out, there's a right of first refusal or something there, so that there's no mix-ups down the road.
Okay, that makes sense. So if it's joint tenants, it goes to your real estate partner. If it's tenants in common, you pass it on to your family, your spouse. Okay,
exactly.
That makes sense. And as we get questions in, Russell, you could tell me if there's any inquiries, and we'll go ahead and answer them.
I'm going to give everything to my spouse, and they get to live off of it, and then they'll do the right thing and split it, between our kids and their kids and all of that. Some people aren't as trusting, or they're worried about potentially a remarriage and new stepkids coming into the picture later if they're younger. So what we can do is kind of do that split at the first death, where the deceased spouse's assets are kind of in this protected entity, that irrevocable trust, that the remaining spouse still gets to live off of. They can help pay the mortgage, still maintain the kids and help pay for their schooling and all of that, but they can't change the beneficiaries. So you can say, my half, I want to go to my two kids, and I don't want my stepkids to be involved, and you can guarantee that through that irrevocable trust, and still let your spouse live off of it, so that they're not all of a sudden losing half of their income and half of the assets that you guys grew together.
Okay. So it probably, and that's another, I guess, great reason to check in with your attorney every 3 to 5 years on your trust, or anytime you have some kind of major family change, right?
Yeah, exactly.
Okay. Excellent. Anything that I have not yet asked you that you'd like to share?
Well, I think a big one is picking trustees. So that's kind of who's in charge of managing the assets and making sure that they get to who you want. So to your kids, and if they're minors, who's going to be managing that money, who's going to manage your real estate or deal with selling it when you're deceased, or rent it out and all of that while the kids are still young. It's a really pivotal role, and most people go to family members, whether it's parents, siblings, aunts or uncles, all of that. But not everyone has family that they necessarily trust or that are nearby that can kind of fill that role. So that's sometimes where we work with First American quite often, because they can serve as a corporate trustee to be that independent person to kind of fulfill that role if you don't have someone else that you trust to kind of handle it for you. Okay,
fantastic. Which is actually a great segue to start talking a little bit.
We have a question.
Let's hear it.
So if you you don't have a house yet, you're looking to buy a home. You have one kid, plan on having a second one. Is there any benefit, or would you suggest waiting until you have all your ducks in a row? Or is there, if you have a child and you're planning on buying a home, do you want to get that down and kind of tweak it as you go along?
Yeah, so the question was, if you don't quite have a house yet, but you do have kids and you're continuing to grow, should you do planning now? I say yes, because the fact that you have a child, you really need at a minimum a will to name guardianship for that child. And on the planning perspective, you can always add documents into it later, or not documents, add assets into the trust later. It's all about titling. So you haven't purchased the house yet, but when you do, if you already have your trust set up, you buy it directly in the name of the trust. So there's no mishap. It's already in there and will flow pursuant to your trust terms. We also draft our documents where if you're planning on having more kids, it doesn't say all to my one child. It says equally among my children, how many I have at that time. So if you end up having one more, it'll go equally between the two or three, it'll go a third, a third, a third. So there's ways that you can build in, I guess, flexibility within the document so that it can grow with you without having to go to the attorney every time a family circumstance change. So smart planners will kind of build for that so that you're not always having to change it as times change.
Is it expensive to tweak?
No, usually, so on estate planning, we do everything initially on a flat fee basis because we understand that it takes time and there may be questions that come up, and we're not going to bill you for, you're like, I don't understand that this becomes irrevocable or all of that. So we do it on a flat fee. The little tweaks are usually hourly, and most of the time most often than not, it's tweaks to the guardianship as the kids get older and the trusteeship, because just things change and family dynamics are always changing. So those take maybe 10 or 15 minutes to swap names and get them fixed. So then we just bill for that time.
And to speak to that question too, should you do a trust now or later? Usually if you're thinking about it now, it's probably the time, because if you're thinking, I'm going to be buying a house or going to be having a baby, guess when is the next time you're going to be thinking about doing a trust?
Life gets busy.
Yeah, probably 3 to 5 years from that point, and who knows what could happen. It's just like insurance in a lot of ways, right? I mean, you're kind of protecting yourself and making sure that you have all your ducks in a row as far as the kids, as far as the assets. So moving to asking Nick some questions here on with First American. Talk to me a little bit about, we said that you do investment management and trust administration. We'll talk a little bit more today on the trust administration side. What is trust administration? And we'll ask you some questions about trustees.
Yeah, sure. How much time do we have, right? So really there's two parts of trust administration. And I think most of the time people are thinking about, well, what happens after I pass away? And so, oftentimes our clients are more about, worrying about that aspect of it, and they forget about kind of, well, what happens should I become incapacitated? So really you can think of trust administration as the management of the trust and its assets. So regardless of whether it's during incapacity or at death, then there's work that needs to be done. And so during incapacity, that administration is taking care of managing the real estate if there's real estate involved, managing the liquid assets, making sure bills are getting paid. Oftentimes healthcare is associated with that, so we work with the appointed individuals who are making healthcare related decisions to make sure that nursing homes are being paid and prescriptions are being taken care of, what have you. And then of course you have the worst aspect of it, which is at death, right? So there's a whole list. In fact, we have a 8.5 by 11 in 10-point font, and it covers the entire page of things that have to be done once the last trustee passes away.
Got it.
So I think a great way of looking at it, and one of the ways I kind of describe it, is you're managing a business essentially. The trust governs what's going to take place with all these assets and to whom, and it's the administration that makes sure those things get taken care of.
I see. So how do you go about choosing a trustee?
It's a great question. Like Joe mentioned, it really oftentimes boils down to the family dynamic. Can you trust the individual first and foremost? Are they close in proximity? Do they have a level of expertise in managing real estate, picking proper financial advisors, tax planners, etc.? Sometimes people don't have children, so then it becomes an issue of, well, I don't have kids to take care of it for me, so I got to find somebody to do it for me. So it can be complicated. The good news is, like Joe was saying earlier, is that it can change over time. So oftentimes what we see is, where they've maybe named First American Trust when their kids were younger, and as their kids get older, they think, well, maybe it's time that we get our kids involved, and so they'll make that change, and maybe they'll keep us on as a co-trustee, where we can be there to support the family. So it changes. There is no perfect answer to that.
Okay. And what is a corporate trustee, and at what point does it make sense to consider a corporate trustee?
Yeah, so a corporate trustee is essentially a bank or a trust department within a bank. So, name a bank, Wells Fargo, JP Morgan Chase, they have trust departments. We happen to be a trust company with a federal savings bank charter, essentially. And I forgot your follow-up to that. I'm sorry.
At what point does it make sense to consider a corporate trustee?
I mean, I personally think it's probably one of the most underutilized resources. Obviously you have those extreme examples of complex assets, lots of income-producing real estate, business interests. That oftentimes is a perfect fit. But that's not everybody, right? So oftentimes it's someone has maybe one or more income producing properties that they're managing themselves, and they just can't seem to get their arms around, well, my kids are going to have to take care of this. So maybe someone who has the expertise and the experience should be doing it. Blended families, I mean, you guys were talking about that. When you can have an unbiased third party come in and try to keep the arguments to a minimum is oftentimes when we find ourselves getting involved. Or like I said earlier, if you don't have family in close proximity or no family at all, I mean, that's oftentimes what we see come through our doors is people that just never had kids, or their kids are Midwest, East Coast, and they've realized, usually because they've talked to a terrific attorney, that, hey, there's going to be a lot of heavy lifting that needs to be done, and our kids are too far removed, or our family's too far removed to be able to do it.
Okay. So as far as what is being managed in the course of trust administration, you mentioned real estate. Obviously, that's a big piece of management. What are some of the other things that, as a trustee, that you would be managing within that trust?
Yeah, everything A to Z. So, whatever the underlying assets of the trust are, so whether it be real estate, stocks, bonds, business interests, vacant land, oil, gas, mineral leases, you name it. Whatever asset falls, under the trust, it'd be our responsibility, or the individual who would be appointed if it wasn't First American. It'd be their responsibility to administer that. And there's a lot of liability that comes with that also. So typically, if it's just an individual, who's acting as trustee, they're going to be responsible to all the beneficiaries as far as every decision that they make. And so there's a lot of liability in that.
So that would be a benefit of hiring a corporate trustee.
Yeah,
okay.
Absolutely.
So of the different trusts and trust administrations that you've done, what would you say are some of either the most interesting, challenging, or strangest pieces that you've had to manage?
Well, I think really it's relationships. We're in a relationship-based business. The nice thing about the trust is it really is the governing document. What the trust says goes.
Right.
So really things get quote unquote hairy when you're dealing with multiple beneficiaries, blended families. And so it's more about the relationship and getting people to see that, well, this kind of is what it is. We can find a way to get along here, and we'll try to do this as efficiently and as quickly as possible. So without outing too many of our more difficult situations, it usually all boils down to the beneficiaries, who gets what, and making sure that everybody's really coming together to get it done.
Okay, so as far as challenges, definitely managing the relationships, I would imagine,
first
would be
and
very
foremost.
challenging. How about just for fun, any? I was referred once to an attorney that was doing a trust administration, had a client that had a whole bunch of timberland out in Michigan, and I figured, how do we get rid of this? Who sells, lumber fields, essentially?
Yeah, right.
Any strange situations, any unique assets that you've ever come across?
So we have a little, saying that we do, planes, trains, and automobiles in addition, and we've done everything but trains at this point.
Really?
So
okay.
we've done wine collections, art collections, collections, jewelry, firearm collections.
Wow.
We've done, odd businesses, that like you were saying, the timber field.
Yeah.
And we can administer and hold title on real estate in all 50 states. So oftentimes some of the more complicated administrations have to do with business interests, partnerships, or real estate that may be outside of our regional footprint here in Southern California. But yeah, we will do it all. And we've seen it all. So.
Fantastic. Well, any questions that I haven't asked that you think will be valuable for people to know about trust administration and what you do?
I think first and foremost, have the conversation with your beneficiaries, with your family. We were talking before we all got started here, about sometimes things coming in that people haven't had that conversation. And oftentimes you do the planning and you try to get out in front of these things and you leave out what we call the family conversation, which, you don't want to save it for Thanksgiving around the dinner table because it may get a little heated. But, just getting people to come together to really understand, this will happen inevitably. And if it does, here's how we see things playing out and how we'd like to see things play out.
Right.
So, and that goes back to, the complicated part being the relationships. If everybody knows what's going to happen, it makes it a little bit easier to do the administration.
And hedging off of what Nick said is having a concise document that's specific and not vague is really important for your trustees. So many times I've worked with both corporate and regular individuals as trustees, and they read a sentence and they're like, well, I don't really know what this means. Is the kid getting the house and the contents, or is it just the house and are we splitting the contents? What does this mean? So having a good document, which is prepared by someone who's actually talked you through all of these items, is really important, so that you're not having to go to court on the back end to say, I have two different beneficiaries that are disagreeing on what this one sentence says on sometimes their biggest asset. So then you're having to get a court order to weigh in on it.
Right. Well, it's like they say, right? Failing to plan is planning to fail, and I think that's what we're talking about.
Yeah,
right?
absolutely.
A lot of people think about building wealth, about building a legacy, but then there's that piece of protecting it and planning how do you pass it on. And so hopefully, this was good information. Any other final closing thoughts from either of you?
No, I don't think so.
I like not having a plan is planning to fail. And I always say get 80% comfortable with everything that you're setting up and just do it, and then you can tweak it as time goes on to get to where you're 100%. This is exactly how I want it. So 80% is better than the 0, because that's when everything goes crazy.
Excellent. Do we have any questions from people viewing?
No.
Okay, well, fantastic. Well, I'd like to thank Nick and Jill for being with us tonight and for sharing all this information. We'll tag the two of you on the post so that hopefully if people have other questions they can reach out directly and create some engagement. And just thank you so much for being with us this evening. The next event we're going to be doing is September 13th. At 5 o'clock, we're going to do everything you'd like to know about being a first-time home buyer, how to get into the market. So won't have anything in August, but that'll be September 13th if you want to put it on the calendar. And hope everyone has a great night.
Thanks.
Thank you.